Donald Trump's former chief of staff when he was president, Mark Meadows, files a motion to dismiss. And of course, we love ourselves a good motion to dismiss here. So we're going to unpack it in detail, go through the full filing because it has pretty serious implications. This is in the case of Big Fani versus Donald Trump. It's taking place out of Georgia and it's a racketeering case. And there's 18 other co-defendants aside from Donald Trump and from Mark Meadows. Meadows is one of many people who are caught up in this big overbroad prosecution from the Georgia DA. And he's now saying, I am immune from all of this. I was a federal officer. This is a state case that should have been brought in federal court. It is not. And the Federal Supremacy Clause means that I am immune. So we're going to go through that. We've also got some other stories about Mark Meadows because he's kind of a key witness in another case, which might be the classified documents case. And we'll check in on that with some reaction from Mike Pence and the update on the story. But the motion you see here, Mark Meadows, state of Georgia versus Mark Meadows as the defendant, and he's writing this on behalf of himself. He's one of 18 others. Donald Trump is another one. And it's the state of Georgia versus Mark Meadows, but notice that we're not in state court. We're actually in federal court, the United States District Court for the Northern District of Georgia. Meadows is trying to remove this. He's saying Fani doesn't have jurisdiction. She's bringing basically a federal case in state court. Can't do that. 34 pages. We'll hit the highlights. They filed a correction, but this is the memo in support of the motion to dismiss. And so they write the generic motion. Here we're filing this motion and they back it up with a memo. So this is what it says. All right, Your Honor, federal judge, federal court. Defendant Mark Meadows, Trump's former chief of staff, moves to dismiss the indictment against him under the rules. As a federal official at the time of the charged conduct, he is immune from state prosecution under the Supremacy Clause of our U.S. Constitution. So remember, Donald Trump, in all likelihood, is going to be able to claim each one of these same type of protections. And so these arguments are almost just like a trial run right now to see what this judge does with this. And he'll file it. You would expect to see something very similar to this filed by others or very similar to get to this same point. Meadows is now asking for a removal and a dismissal back to back. We haven't even waited for removal yet. That's how aggressive he's being, right? We're going very, very quickly here. You would expect similar arguments to be made by other defendants. And if the entire case gets removed, then they'll all be in federal district court rather than Fani's state court. They continue. Big Fani's prosecution of Mark Meadows threatens the important federal interest in providing the President of the United States with close, confidential assistance firmly entrenched in federal law for nearly 100 years. Referencing Elena Kagan, who's a current Supreme Court judge. She wrote that in a law review article. Oh, we love that. And gives rise to precisely the sort of state interference in federal affairs the Supremacy Clause prohibits, saying centuries of federal precedent make clear that states may not impede or interfere with the actions of federal executive officials when they're carrying out their laws. So when they're doing their jobs, you can't interfere. Why could this be a problem? What happens if we have a bunch of Big Fanis who decide that they're going to use their offices to impede a political candidate that they don't like? Oh, is that happening right now? We've got Big Fani and Alvin Bragg doing the same thing. We've got Jack Smith doing the same thing on 2 federal cases. So the states can't act like little dogs nipping at your heels when you're trying to govern the federal government. In this case, a federal official carrying out his duties is not obliged to consider state criminal law at all before acting. They reference another opinion from Yale. Federal courts enforce these fundamental constitutional principles by granting immunity in state prosecutions and dismissing charges under Rule 12b. They say, Mr. Meadows removed this proceeding from Fulton County, Georgia, and he's writing as though he's already done this. We have not had a hearing on this removal yet. This is still pending. I believe the removal is scheduled to happen a week from today, I think on the 28th. But he's saying, I've already removed it. I've already invoked the power to do this and it's done. The day after I was indicted, I filed it. Now, the court declined to send this back to the state level, which means that we're going to have a hearing on this. And they say, also, Judge, while you're considering this request, we submit a motion to dismiss. Why? Meadows is entitled to removal and immunity. The court can decide to permit removal and notify the state court, which will stop further state proceedings and then address this motion on a more traditional schedule. They say stopping the state's criminal proceedings promptly is important. Both the Supremacy Clause and U.S. Code in Section 1442 protect federal officials from lawsuits and criminal charges in state court, not just from liability. The suit itself, not just the result of the suit. But as set forth below, the basis for granting immunity to Mr. Meadows is well settled. The court Court should therefore move swiftly on both removal and immunity. They notice the judge. Your Honor, it's clear Big Fani is seeking to move quickly in the state court so that Mr. Meadows will irreparably lose his constitutional and statutory protection if you don't do this quickly. Since 1890, since a decision in Nagel, the Supremacy Clause has been understood to stop states from bringing suits under state laws against federal officials. Federal official, including a former federal official, is immune when the charged conduct has some nexus with furthering federal policy. So if Mark Meadows is the chief of staff and he is investigating election fraud at the behest of the chief executive of the entire country, which is called the president at the time, who still has an obligation to make sure we have fair and free elections, is that a nexus? I would say so. Can reasonably be characterized as complying with the full range of federal law. Obvious analysis. As chief of staff to Trump and leader of the office of the president, Mr. Meadows served a critically important function, something that's been firmly entrenched for 100 years. The charged conduct here has far more than, quote, some nexus to his official duties. It involves literally the core aspects of the role. That's why he's in this role, to go execute the president's will. And while Meadows' conduct is alleged to have violated state law, it can reasonably be characterized as complying with the full range of federal law. So Big Fani can say, maybe it violates her state. That's her interpretation. But we're already in accord with the federal law. And that's what matters for Supremacy Clause immunity. Neither Georgia in its indictment nor the United States in its recently charged case has accused Meadows of violating federal law. Nobody's saying he's done that. But they are saying that about Trump. Okay, so now we see something that we can distinguish Trump with. So neither Georgia here nor in another case, which is United States versus Trump, where Meadows has not been charged. That's the federal case. Nobody's charging him of federal law, violating federal law. They are for Trump. So that means that the motion to dismiss, this exact motion to dismiss, you cannot copy and paste this for Trump. Got to delete that sentence. Even if they had, moreover, a federal official does not lose the Supremacy Clause immunity based on the violation of the law where the violation was not clear and willful. It's got to be more. They have kind of a little bit of immunity built in. It's got to be clear and willful, kind of like qualified immunity, but maybe to a lesser degree. Mr. Meadows is thus entitled to have the charges against him dismissed. He can raise the defense now, and that is exactly what he is doing. So they give us a little bit of background here. They say the Supremacy Clause of the federal Constitution provides the following. We love our federal Constitution here. As the Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. In an interpretation from a Livingston case, they say, although the Supremacy Clause explicitly refers only to the Constitution and laws, its implication is that states may not impede federal officials when they're carrying out their laws. Otherwise, they could just bind somebody up in state court, just file criminal charges like they're doing, and stop them from doing anything else. Consistent with that understanding, the Supreme Court has long interpreted the Supremacy Clause to provide federal officials immunity from suit involving state charges to protect federal operations from the chilling effect of state prosecutions. Not necessary for Congress to provide expressly for that immunity when we already have the Supremacy Clause. And it's implied by several acts. Under our Constitution, they say states can neither enact nor enforce laws that retard, impede, burden, or in any manner control federal officers in their duties. And what they cannot do expressly, regulate the enforcement of laws entrusted to the discretion of the federal government. They cannot do indirectly through ad hoc enforcement of their criminal law. So just like Big Fani couldn't pass some legislation or do something that would supersede the federal court, she can't use what she does have to supersede what the feds are doing. So she can't reconfigure the criminal code to be useful in an effort to impede a federal official who is lawfully complying with federal law. Saying these principles were well settled when the Supreme Court decided that case back in 1890. There, we had a different situation. There was a U.S. deputy marshal named David Nagel. He was charged with murder in California for fatally shooting a man while protecting Supreme Court justice. After recounting the colorful facts of the case, the court assessed that whether the Constitution and the laws provided a basis from freeing Nagel from state custody. So he shoots somebody protecting a judge. The state charges him. The court first ascertained that Nagel was acting under color of law because he was protecting the justice, and he rejected California's argument. The court said, well, we've got immunity here. The court said he did no more than what was necessary and proper for him to do, and they said that they can reasonably extend that under the law. Since Nagel, the Supreme Court has addressed Supremacy Clause Clause immunity only rarely, hasn't come up much. Two most notable decisions came within 20 years of Nagel. In Ohio versus Thomas, in the Supreme Court case, we had another one, this one from 1899, the court held that Ohio could not prosecute a federal official for serving margarine in a home of a disabled veteran without placing a sign in the window. The court held that Congress had appropriated money to buy the margin and that serving it was therefore legal under the Supremacy Clause. All right, so we've got a margin case here. We had another case, 1906. The court affirmed the denial of immunity for soldiers when they were prosecuted for murder. So they're soldiers, right? Now we're distinguishing what category of people, soldiers versus federal officials. There was conflicting testimony about whether the fatal shots were fired in hot pursuit. The court held that pretrial immunity was unavailable based on the facts of the case. Now here, under Nagel, a federal official is entitled to immunity if he was authorized to do what he did under the laws. At the general level, the question turns on whether the officers act have some nexus of furthering federal policy. While the phrase "no more than necessary" might suggest a narrow scope, so did Mark Meadows exceed the scope of his authority, they unanimously agree that immunity turns on the official's general role and the authority. The 11th Circuit simplified a lot of this. They said that the Supremacy Clause bars state law liability where the federal officials act, so Meadows or Trump, have some nexus with furthering policy that complies with a full range of federal law. Once a federal officer, like Meadows or Trump, makes a prima facie showing, meaning just on its face, they say, yeah, we've got immunity, then the burden shifts over to the state, which is great. So you say, look, I can show that I'm a federal official. I can show that I was doing this in furtherance of protecting elections. And once I meet that burden, it goes back to you guys, Big Fani, to show why that is not true. Therefore, the district court should sustain the defense of immunity under the Supremacy Clause. Here's some of the argument. They say that Meadows carried out the conduct of chief of staff. That's what creates that nexus. The conduct charged here by Mark Meadows falls squarely within the scope of his duties as chief of staff. And there's federal policy that underlines his role, and they're going to give us a list of it. He needs to show only some nexus, but here it's much closer than that. It's like his job description. This court succinctly summarized the charges in its own summary. They said that Mark Meadows met with Michigan officials to talk about the election. He messaged representatives from Pennsylvania to talk about a special session. He met with somebody to talk about, quote, disrupting and delaying the joint session relating to counting votes. He attempted to and was prohibited from physically observing a non-public audit, the Georgia audit. He arranged a phone call between Trump and a chief investigator. And he messaged somebody called Investigator Watson, and he solicited a phone call or asked the Secretary of State to do something, right? So they say Meadows' team, say, Your Honor, taking these allegations is true for assessing immunity. There's obviously a clear nexus between what Meadows was doing and his role as chief of staff. The question is not whether Meadows was specifically authorized or required to do each act. Like, was he allowed to send that text message? Was he allowed to make that phone call? Was he allowed to show up to that location? But the question is whether they fall within the general scope of his duties, and they surely do, they say. As noted, those duties included information gathering, providing close and confidential advice to Trump, and the way that the state characterizes any of this is wholly irrelevant. These were his duties. They were core functions of anybody who's a chief of staff. This is what they do. They attend Oval Office meetings. They contact state officials. They visit state buildings. They set up phone calls. They have a plain connection to all of this and the White House. So the nexus here is readily apparent. Only by virtue of his role as chief of staff was he involved in the conduct. If he was not chief of staff, he wouldn't have been involved in any of this. His federal position was a but-for cause, meaning but for being the chief of staff, none of this would have happened to him. They say if Mr. Meadows had absented himself from Oval Office meetings or refused to arrange meetings or calls, he could no longer have been the chief of staff. So what the state is doing, Your Honor, is it's threatening this very important interest. How can a chief of staff do anything if they're going to be under threat of state interference? Even the most dedicated federal servant would be reluctant to do his job conscientiously if it could mean prison time. And that's why the Supremacy Clause exists. If Georgia and Big Fani could prosecute a chief of staff to the president based on a course of conduct that is simply arranging meetings with legislators, presumably from states too, they could prosecute him as well. The implications are staggering, and the prospect would hobble not just the chief of staff and their ability to carry out the role, but how the president functions generally. This is contrary to the law. We want a president who's nimble. We want effective advice, an effective assistant, and the Supremacy Clause does not permit this conflict. So in other contexts, they say Congress and the federal courts have recognized the need to treat the president's advisors differently. They need candid communications. The law must provide elbow room so that they can go have these conversations. The president has discretion. We give them some room to operate. You're not looking over their shoulders every time saying, is this according to Big Fani's law? Am I allowed to do this? As the DOJ explained in the Obama administration, prosecution in a non-Trump case. Absent immunity for the president's closest advisors, if they don't have it, congressional committees could compel them to do all sorts of stuff. And so this prosecution is obviously a case of a nexus between his conduct and his job. Now, it's also, they're saying he's also in full compliance with federal law. He didn't violate anything. Nothing that he did was unreasonable. The whole point of carrying out his duties is to do all of this. He was contacting board of managers, and they don't allege that he violated federal law or the Constitution at all. In fact, they're saying, yeah, there's no evidence that they're even saying he violated federal crimes. Why? Because in Big Fani's indictment, they're only referencing Georgia codes, OCGA, Georgia statutes. And while there has been a recent federal indictment, this is going to distinguish him from Trump. Mr. Meadows is neither charged nor identified as a co-conspirator in the indictment. He's mentioned by title 4 times in connection in that case as the defendant's chief of staff, as the defendant's chief of staff, as the defendant's chief of staff 4 times. So they're saying, okay, so they know he's in here. They know his conduct is here. They know who Mark Meadows is. They've reviewed his conduct. They found that Trump's conduct is criminal, but not Mark Meadows. So nothing suggests that he violated federal law. So if Big Fani can't bring the charges in state levels, and the feds have already investigated him, presumably, and have found nothing wrong, case has got to go. The core principle behind the doctrine of the Supremacy Clause immunity is that federal law, not state law, must govern the conduct of federal officials in carrying out their duties. States may not second guess or superintend that role. This matter provides a paradigmatic case for applying immunity. The U.S. Department of Justice brought charges related to the aftermath of 2020, including Georgia. They omitted Mr. Meadows, and while Fulton charged him with a very similar set of crimes. So even if a federal official does exceed his authority under federal law, that doesn't forfeit their Supremacy Clause immunity. And the Supreme Court, federal courts have consistently held that federal agents are immune from state law prosecution so long as they did not violate federal law maliciously or with criminal intent. And even if the court were entitled to conclude that Meadows is not entitled to immunity, he's still protected otherwise. He's still got the First Amendment and the 14th Amendment, and he's going to raise those up later. The First Amendment has its fullest and most urgent application when we're talking about the running for political office, so he can say and do things. And they say here, whatever one thinks about his phone call with the Georgia Secretary of State, it's a phone call, and he's allowed to vigorously and tirelessly represent and do his job. So Mr. Meadows, if you don't dismiss this on federal supremacy claims, we're going to make another claim under the 14th Amendment, Due Process Clause, and First Amendment, because they are criminalizing conduct, and the statutes that are currently in place are unconstitutionally vague. Man, so they're throwing everything at this. So it's also a notice problem. So if you're going to now say that what Mark Meadows is doing is a crime, well, that's news to me, and that's news to every single chief of staff that's going to come down the line, because this all used to be normal, allowable conduct. Now it's not. So the laws are unconstitutionally vague for not giving me proper notice of what is illegal. And that's why these charges should be dismissed, because they're unconstitutionally applied. If Georgia law really does apply to Mr. Meadows, then it violates his rights under the Constitution. Accordingly, the court should dismiss all charges against Mr. Meadows in the indictment. Signed, sincerely, your friends, George Terwilliger. Good motion here. And these guys are moving quickly, my friends, moving very quickly. 30 out of 34 pages. We've already got a motion to dismiss. All right. So Fani filed those charges like, I don't know, what, 2 weeks ago? Like nothing. And we're already making motions in federal court for federal removal and a motion to dismiss. Now, there's some things to distinguish here, because Trump obviously has a parallel case, and they are prosecuting him out of the January 6 cases out of DC. And we'll see if that causes the arguments to be different from Trump and his team, which I'm sure it will. But there's another component to this, because Meadows may also be charged. Some people are thinking maybe he gets charged in January 6 case in some superseding indictment or something like that. And he also might be a key witness in the documents case. So ABC News is reporting, and they had, I think, an exclusive on this, that the special counsel, Jack Smith, interviewed Mark Meadows, and Meadows told him that he doesn't have any knowledge that Trump ordered him to declassify the documents. So they're very excited about this. But they say, appearing to contradict Trump's claims, former Chief of Staff Mark Meadows told Jack Smith he could not recall Trump ever ordering or even discussing declassifying a broad set of materials, nor was he aware of, quote, any standing order from Trump authorizing the automatic declassification of the materials, according to ABC News. So we're asking ourselves, right, who are the witnesses going to be? What does the evidence look like? The Georgia case looks like it is, weaker by the day, especially if the whole case gets removed to federal court. I mean, Big Fani's going to lose just by jurisdiction alone, and we'll see how she takes that. But we've also got questions about the Florida case, and so Mike Pence, who also has a classified documents problem of his own, is now brought in to ask, hey, Mr. Pence, do you know, did Trump declassify anything?
Joining us now is former Vice President and current presidential candidate Mike Pence. Mr. Vice President, thank you for joining us. I want to start with our new reporting.
Thank you, John.
I want to start with our new reporting about Mark Meadows. As you know, Donald Trump has claimed that all those documents he took with him to Mar-a-Lago he had declassified. But we are learning that Meadows has told investigators that he knew of no such broad declassification order from Donald Trump. What about you? Had you heard anything to suggest that the president had issued an order, even a standing order, declassifying documents like that?
Well, first off, the handling of classified materials is enormously serious in the life of
not
the
that
nation.
Serious.
But I can't really comment on your
You had
reporting.
him,
but
Joe had him, Trump had him.
In my case, I was never made aware of any broad-based effort to declassify documents. There is a process that the White House goes through to declassify materials. I'm aware of that occurring on several occasions over the course of our 4 years, but I don't have any knowledge of any broad-based directive from the president. But that doesn't mean it didn't occur.
That's right.
It's not something that I ever heard about.
That's right. It doesn't mean that it didn't occur. And as we've made the argument here before, the act of moving the boxes is constructive decision-making. Trump just does things and stuff happens, right? That's how power works. So he makes a motion, he moves something, he takes action in one way, shape, or form, presses a button, doesn't matter, and everybody responds. So it's a very interesting motion, and we're starting to see some of these pieces come into play in a unique way. I'd be very curious if Big Fani's case got pulled up into the federal level, because then it would very much overlap with Jack Smith's case, which was a concern we had from the very beginning when people were even wondering, is Big Fani coordinating this at all with Jack Smith? And it turns out not. So you might start with 4 cases and then turn into like 3.5 cases, and then maybe really like 3 cases. And then if Alvin Bragg decides to defer his cases, right, that one's kind of stalled out, we just have the federal cases. And so it's a very dynamic, very fluid situation. Of course, we're going to continue to cover it, my friends, as it unfolds, including the Meadows motions, and the government will be responding to this. We'll take a look at that. So thank you for subscribing wherever it is you're watching this, and we'll look forward to seeing you on the next one.